The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. Thank you so much for spending your evening with us. One case will be submitted this evening. That case is Morgan Honomichi and others versus Valley View Swine, LLC, and JBS Live Pork, LLC. Mr. Roemerman, you may proceed.
Mr. Bylund will go first, Your Honor.
All right, very well. Mr. Bylund.
Thank you, Your Honor. May it please the court. My name is Jacob Bylund. I represent JBS along with my co-counsel Shannon Soul. Mr. Roemerman represents Valley View, the co-defendant in the case, and Mr. McAfee represents the amicus parties in the case. Thank you for setting this argument for an evening setting. This is something that is of interest, not just to the parties in this case, but is of interest more broadly. The parties in the case have asked the court to revisit the Kock decision. Both sides of the case have submitted briefing requests that the court do so. Obviously, the parties request that the court revisit the Kock decision going in different directions, but I think there's a general agreement and request that the court revisit that decision. I want to start by touching on what this case is not about, and that is the first half of the Kock case. The first half of the Kock case dealt with the takings clause and dealt with whether or not the legislature has the power to basically immunize facilities from liability, including for diminution in property value. And the Kock court
Can you
found
tell me what's changed since the Kock case to cause us to revisit it?
that would cause the court to revisit it?
Yes.
Well, first, the Kock case was decided based upon three factors that the court articulated. After first finding, basically walking through the analysis and finding that the statute was a reasonable exercise of the state's police power, the court then found, based on three factors as applied to the Kockes, that the statute was unconstitutional as applied to them. The court then ended that section with a sentence that said it made no determination about whether or not that applied to any other case. What's happened in the 14 years since Kock has been decided is that every court deciding the issue has followed those same three factors as though that were a specified test, and has found that every other plaintiff, the statute was unconstitutional as applied to them. We think that that is incorrect and needs to be revisited in terms of what's...
But if we applied the test, the three-prong test,
Right.
to the facts of the case as at least alleged, the first is the Kockes, I may be mispronouncing it, I'm sorry, Kockes received no benefit from the confinement facility. That remains true here, does it not?
No, we disagree with...
The homeowners are getting a benefit from, and I'm curious what that is.
It's not from the facility itself. It's from the regulatory scheme at issue, which we've articulated in our briefing. If you look at the regulatory scheme itself, and we've articulated this in the briefing, the Honomichis, as an example, have a 1 or 2 acre parcel, and because of the regulatory scheme, and I've got a copy of the bill that this was passed with, which is printed double-sided and was a very voluminous bill, the Honomichis have the ability to exclude the existence of a facility on a 250 acre tract of land surrounding their home. They also, as part of the same bill, got the nutrient management plan and other aspects of the regulatory scheme. So I do think that there is a benefit to the statutory scheme.
But do those benefits override the smell of this stuff?
Well, do the benefits override the smell of that? I don't think there's a dispute, Your Honor. I don't think I would dispute that there is an odor associated with hog production. But there's a comprehensive regulatory scheme that exists to help control and mitigate that. That is why we have setback distances. If you go back to the time the Kock facility was first built, I believe the setback distance was 750 feet. And then it extended to 1,000 feet, and now it's 1,850 feet. So we're getting up close to a half-mile setback distance from the CAFO facilities, and that's how you get to this impact of a single household having 250 acres.
Counselor, are you asking us to overrule Kock?
I don't think it would technically require you to overrule Kock. The Kock decision went through the entire analysis, got down to the very end, articulated these three factors that were specific to the Kockes, and said that because of those three factors, it was unconstitutional as applied, and said it was limited to that case. So I think it's not necessarily to go back and quote, overrule Gakey. It was as applied to them, and we don't need to revisit that decision. That's in
Oh,
the
but
past.
that's right, but it seems to me, I mean, I agree with you, somewhat, but the focus in Gakey is the oppressive burden. I mean, that's a phrase that is repeated in Gakey several times. The oppressive burden on the homeowners, and there was a three-pronged test that we were beginning to go through, no benefit. They were there long before,
The home, yes.
and there was no remaining right to recovery. So, in some cases, you might not be able to prove oppressiveness because, for whatever reason, the odors don't extend or whatever. I mean, it's a factual question as to whether there's a oppressive burden or not. If you didn't use the nearby property as a home and you used it as a chicken slaughtering house, you probably wouldn't have oppression and so forth. But I guess I'm making a couple comments, but the focus of GACI seems to me to be on the oppressive nature of this industrialized facility coming to the neighborhood.
Well,
Do you disagree with me? Or?
Yes, I would, on a number of
sure.
respects. First
You
of
bet.
all, I would disagree with the characterization of an industrialized facility. This is how hogs are raised today. This is how modern hog production
Well,
operates.
whether it's industrialized or not, the point is that they were, I mean, under the common law, the notion of who came to the nuisance was critical, of course.
Yeah, and that's still the case. But what we have here is existing agricultural areas with agricultural facilities. In fact, the Division C case, there had been hogs on that site going back for generations. And we're still having producers subject to the nuisance claims, still going to court on those claims. In that case, importantly, and this is really the issue with the three-prong test, we've got a situation where the district court will apply the three-prong test, find the statute unconstitutional, as the court did in Division A and Division C, then later determine that the plaintiff's claims were frivolous, as happened with respect to 3 of the plaintiffs in the Division C case, and sanction the plaintiffs for having filed a frivolous claim. And I don't fault the district court for doing that. It's because of the standard that was articulated, or what has been interpreted by the district court as a standard of that three-prong test, that you have a district court who can allow a claim to go forward by a plaintiff and find that the plaintiff has a constitutional right to assert that claim, and then after the trial is over, sanction that plaintiff for bringing a frivolous claim.
You're telling me there's a problem with the three-part test. What's your test in order for a lawsuit, for the statute not to be unconstitutional?
We believe that if you look back at the Gakey case, the court ran through the standard. It talks about what the inalienable rights was and about how it doesn't prohibit reasonable regulation. It talks about the presumption. And then the court went on to find that the statute was a reasonable exercise of the state's police power.
Tell me what your test is as an as-applied test, if we were going to keep as applied.
We believe that the inquiry should end at that point with the determination that it was a reasonable exercise of
So
the
all
state's police
hog lots will be good as long as they meet the regulations that you say were passed by the legislature.
Yes, well, if the legislature, if the facility is operating in compliance with the law, and it's not operating in a negligent manner, it's consistent with 65711, then yes, we would say that the statute applies, and that we should not have the district court having to sort through a long litany of factors. Now, we're not asking the court to change a long line of jurisprudence with respect to this unduly burdensome test. That's not the point of the argument. The issue is, in the Gakey case, we had an articulation of these 3 factors, and that has become the standard in the state. And we think the court needs to revisit the statutory scheme and find that the statutory scheme, meets the legislature's objective as the court held in Gakey, and determine that it is within the police powers of the state.
Counsel, I want to go back to your comment earlier about what things have changed, what circumstances have changed since Gakey. And you referred specifically to the setback change,
Right.
from 750 feet to 1,850 feet.
Right.
Could you direct me in the record to support for the notion that that change in setback makes a substantial difference in the extent to which the property owner adjacent to the facility is suffering an oppressive burden?
Well, I'd have to go back to the DNR regulations that we refer to and the regulatory scheme in the bill itself. The reason why you have setbacks that were originally implemented in 1995 was because of the odor associated with livestock. That's why the regulatory scheme was initiated, and then since that time, that setback distance has expanded over time.
What I'm focusing on is there expert testimony or lay testimony suggesting that that difference in setback makes a big difference in the extent to which the people in the plaintiff's position are oppressed by the smell?
And Your Honor, it escapes me if I can point to you a place in the record. There was certainly expert testimony in the lower court. There was expert testimony about the reasonableness of the operation. There was at one point an air modeling expert in one of the case. I don't think that was ever really contested. That the further you move away from the facility, there's a diminishing of the odor associated with the facility. I don't think that was ever really in question in the lower court, Your Honor.
Mr. Bylund, did the district court actually use an as-applied challenge in making the decision here?
I think that the lower court would say that was what was done, that it was an as-applied challenge, and I think that, to use the plaintiff's phrase, that the plaintiffs identified with the circumstances in the Gakey case, and that was really the end of the analysis. I don't think the court intended, because this court said in Gakey that the statute was constitutional and a reasonable exercise of police power, I do not think that the judge went against that decision. I think she found the statute she intended to say that it was unconstitutional as applied, but of course she applied these factors that meant that all these plaintiffs in all these cases get to have their claim continue, including those that, there's a pending motion for sanctions against one of the plaintiffs in the Division A case right now for some of these issues that we've talked about before. And I see that my time has expired. It looks like it's going down to a minute, but I ran down to 0, I thought, before. Thank you.
Mr. Bylund, thank you as well. Mr. Roemerman.
I think we've used up appellant's time and we're into amicus time, so I'll speak on rebuttal unless the court wants to grant me a few minutes here.
Well, did you intend to?
We did intend and
All right, I think I took your time up, so why don't you come forward?
I appreciate that consideration, and in light of that, I will be very brief. I take issue with oppressive. My clients in this case doubled the setback distance. The closest plaintiff is 2/3 of a mile away. To put that in perspective, that's approximately the distance from this courthouse to the Polk County Courthouse on the far side of the river. I do not believe it's oppressive, but my belief doesn't matter. If this case were tried, because it's come up pre-trial, you would find that most of the neighbors do not find it oppressive. Now,
Well, then maybe you win, I mean, quite frankly. The question, in part, I think, is whether there's a categorical rule. I mean, there's been talk about categorical rules, and I think your position is you comply with the regs, that's it. But another approach might be to say, well, let's see what the facts show, and it might be that a home is 1,300 feet or 1,500 feet away, but because of the topographical features and the nature of the operation and so forth, it still might amount to a nuisance. You see my point?
the problem with the Gakey test as applied is, for example, we had flagship plaintiffs. One of the flagship plaintiffs was Mr. Mike Merrill. Mr. Mike Merrill's was part of the ruling that said the statute is unconstitutional as applied to him. He testified, and it's in the summary judgment record, that he never smelled this facility in the year he filed the lawsuit, and he smelled it maybe 2 or 3 times in the entire following year. Now, applying Gakey, the district court said the statute was unconstitutional as applied to Mr. Merrill. Mr. Merrill's spouse works at the Cargill, now JBS, slaughter plant in Ottumwa, and presumably if there weren't pigs to slaughter, she wouldn't have a job. But as applied to Mr. Merrill, as well as all of the other plaintiffs, there was no particularized benefit to her.
If the district court made a mistake or made an error in applying the Gakey test, does that mean we have to throw the test out?
No, I think that the problem, Your Honor, is that the Gakey test in terms of the oppression is actually a wholly subjective standard. I understand it's phrased as if it were objective, like nuisance law is phrased as if it is objective in the sense that it's a reasonable person standard. But since there is no way to measure odor like there is sound, no decibels and so forth, there is no objective standard, so it becomes entirely subjective. And I don't know of any other area of the law where the constitutionality of a statute turns upon the subjective perceptions of an individual plaintiff.
I saw this morning, a bill was introduced in the legislature that in 2 years they have to get rid of 1/3 of all the regulations in the administrative code. Now, what happens when they get rid of these setback laws in the nuisance for the hog lots? What do you do then?
The setback,
The
Your Honor,
setback law, all these DNR regulations dealing with hog lots. What if those are repealed or gone in a year from now if we were to overturn Kecky? What do you do then?
well, to begin with, Your Honor, the setbacks are statutory, not regulatory. So I'm unfamiliar with that law, but presumably it wouldn't impact, because all the setbacks and most of the regulations we're talking about are statutory.
But if the legislature, we overrule Kecky and the legislature amends those laws next year, what do you do?
If the legislature changes the law, then any law, then I presume that a litigant can take it to this court and see if the constitutional issues have changed. But that, I think, would apply to any hypothetical change in the law in the future. All we can do is deal with the laws that the legislature gave us, and because this odor is subjective, and it was generally recognized by the legislature that the further you get away, the less onerous it is, they attempted to draw a bright line, and they drew that bright line at essentially 1/3 of a mile. And in this case, the plaintiffs are 2/3 of a mile away, and under the Kecky test, and I don't blame the district court, because I don't think Kecky provided very much guidance, but under the district court found it was unconstitutional as applied to people who didn't even smell it in the year they filed the lawsuit. I see my time is up. Thank you.
Thank you as well, counsel. Mr. McAfee.
May it please the court? I'm Eldon McAfee. I'm here tonight representing my clients, the amicus parties supporting the appellants here, Iowa Pork Producers Association and the Iowa Farm Bureau Federation. Without repeating a lot of what's been said, I guess I want to start with a little background. Your Honor, I believe you inquired as to essentially the coming to the nuisance doctrine, and I want to point out maybe an error in some of the briefing. It's been stated in one of the...
Error in my question, maybe.
Well, no, I'm not going to...
I'm
You're the
open to
judge,
that.
not me.
Well, I ask you to give it your best shot.
I will, thank you. The first nuisance defense law, right to farm law, was adopted actually in 1975 by the Iowa legislature, and it codified the coming to the nuisance doctrine. It basically said, if somebody's there, the livestock operation is there and operating, and you comply with zoning and comply with one other aspect of the law, then you get an absolute nuisance defense, but you had to be in operation first. Well, with all due respect to legislatures, everyone, that doesn't work for the livestock producers. We need, and I'm representing livestock producers, we need a law that allows for growth. And to have growth, you have to have the ability to expand in an existing operation even though the neighbors are already there. And we realize that comes with some concern. The coming to the nuisance doctrine is common law, but the legislature has stepped in here and, as you know, in the purposes clause has looked at promoting growth. And so in 1982, the ag area law was adopted, which this court found unconstitutional as a per se taking. Then in 1995 and again in 1998, this law was adopted, amended in 1998. Neither one of those laws required you to be there first. But what's the trade-off? What is the trade-off? So to give some protection, and now many may not agree with me, but the trade-off is the generally accepted management practices. Now this court in Gakey said that was the same as negligence. I respectfully disagree. The legislature in 1995, when it first adopted 657.11, it had a negligence standard, and that was taken out in 1998.
Is your position that Gakey was wrongly decided? I mean, that's where I think you're going, as I
Yes,
listen
Your
to you.
Honor, it is. To the extent of the inalienable rights clause applying here.
From a policy reason, why should a local landowner not be compensated when somebody comes into their area and takes the enjoyment away from the use of their property? From a policy reason, why should the landowner support the hog industry?
First of all, Your Honor, I believe, again, I'll answer your question the best I can. First of all, not all odor, it takes away the use and enjoyment of property. It has to be substantial, it has to be unreasonable. That is what trials are all about. But what this law intends to do, and if I miss the answer, please, I'll do my best, but to answer your question, this law, like many other states, Iowa's not alone here. All 50 states have some type of law like this. Iowa is alone in finding that unconstitutional. But to answer your question, we require in this law that they adopt generally accepted management practices. Now, can you still have a nuisance and adopt those practices? I'm a believer that many times you cannot, and I think many of the district court decisions have borne that out, jury trial decisions. But
Well, then it may be, I mean, let me just press that. It may be if you don't show a nuisance, you don't recover because you don't have an oppressive burden under GACI.
Right.
So the question might be, I mean, I heard your prior counsel talking about a situation where the landowner said, well, you know, I didn't smell it hardly at all, or maybe once or twice or whatever, but the description that was given didn't strike me as classic nuisance. And it may be in that circumstance, as applied, the statute's okay. But where you do have a nuisance, you have an invasion of a common law right, and then that gets you into the constitutional difficulties.
I
Push back.
respectfully disagree because yes, this statute says if it is a nuisance, we are going to take something that is otherwise a nuisance and say it's not, okay? And I understand that's where all the rub comes. But what we've done is try to protect the neighbors, and I do believe the neighbors receive a benefit from this statute. I believe if the landowner who has to put up a fence to keep somebody else's livestock out receives a benefit from having to pay for that fence just to keep somebody else's livestock out, I believe in this case these neighbors are receiving a benefit from the setback distances, from the master matrix that was recently adopted in 2002. I believe there is a benefit to these neighbors from this statute. Well, that's what the legislature has determined, and I understand we're in front of the court right now determining the constitutionality of that, and that's where I believe the court erred in Gakey in finding that was unduly oppressive. But more so, I believe, as has been argued previously by counsel, I see my time's up. May I complete?
You may sum up.
Thank you. That we have changed circumstances here in the additional regulation. Part of that bill in 2002 that I just talked about that established the master matrix also called for an odor study. That was in the legislation. That odor study was done by the Iowa DNR and determined that as a result of that, I believe it was about a 2-year study, that no regulation was necessary as called for by the legislation to look into it and determine if regulation was necessary. And the Iowa DNR determined by taking readings at the separated distances, mind you, no regulation was necessary. I hope I answered your question, Your Honor. I see my time's up, and I thank you.
Mr. McAfee, thank you as well.
Thank you.
Mr. Kock.
May it please the court. My name is Jennifer DeCook, and I am honored to be here today representing our plaintiff appellees, along with my co-counsel, Steve Wandrow and David Sykes, against the Valley View Swine LLC. Plaintiffs' appellees are neighbors to the confinement that's at issue. Article 1, Section 1 of the Iowa Constitution allows no confusion as to the rights we prize most in our state. We so value the right to use and enjoy private property that we name it and protect it with the first of many rights in our Constitution.
The legislatures every day and cities every day have all kinds of zoning laws and all kinds of setbacks and all kinds of restrictions. And we haven't ruled those unconstitutional. Why, when the legislature comes up with setbacks that allegedly conform with generally accepted principles, why should they not be enforceable and give immunity to the hog lot industry?
Well, because I don't believe that, for instance, a speeding ticket from a speed trap camera like we saw in the Jacobsma case rises to the level of unduly burdening private property. That's the real test.
What about zoning a junkyard next to a residential area?
Well,
If
I
the
would-
city wanted to do that.
Well, I would argue that that zoning law would have the same impact as the administrative code that we've been discussing with these setback distances. There is a reasonable, we have an opportunity with the Article 1, Section 1, to name the rights that we find most inalienable, the most protected rights.
Supposing the situation was that twice a year there was a mild odor, twice a year to some resident, one would be pretty hard pressed to say that's an oppressive burden. State regulation has impacts. People are mildly adversely affected all the time. Even under GACI, it seems to me, you need to show that the burden is oppressive, which is generally a fairly high standard, right?
I would absolutely agree, Your Honor. I think that there's a long line of precedent that we've seen from Weinhold v. Wolf to Borman to Gakey talking about what constitutes an oppressive burden on private property. And those cases are very, very clear. Weinhold is a great example. The court breaks down how many days a year this property was unduly burdened by this hog smell. And then it talks about what percentage of those days the smell was intolerable. There are factual determinations that are made in a nuisance case, but you have to be able to bring the nuisance case in the first place.
Counsel, in Gakey, this court had the benefit of a trial record to assess the extent of the burden on the plaintiffs in that case. Here, we just have a summary judgment record. Is that different? I mean, is the summary judgment record strong enough to affirm this lower court ruling?
We would say yes, that it is, Your Honor. The evidence that was submitted on summary judgment was very extensive. There were depositions taken of all plaintiffs, statements of fact, expert reports were submitted to Judge Szynski. She was very clear in her ruling that she was making a summary ruling in the interests of efficiency. And part of the reason that we believe that she made that summary ruling in the interests of efficiency is because for 14 years with the Gakey standard, we have had this ongoing judicial inefficiency where there is a determination for every piece of litigation under 65711 that this statute is unconstitutional as applied. And if a statute is unconstitutional as applied for 14 years, if you have that level of consistency, you cannot have judicial efficiency. You have litigation, you have motions for summary judgment every single time. You have interlocutory appeals coming from those motions from summary judgment. Then you have a jury trial. Then you have an appeal. Then you have applications for further review after appellate court
So, counsel,
ruling.
should we take a cautious approach and decide this case narrowly on the specific factual record, or act more broadly and decide whether this statute is unconstitutional on its face?
Thank you for that question, Your Honor. I believe that the court should follow precedent on this case. We have Weinhold v. Wolf that first found Section 352 unconstitutional as applied. 2 years later, we have Borman saying it's facially unconstitutional. 14 years ago this June, we had Gackey saying that this was unconstitutional as applied. We do not have a case in this state under 657 that says that this statute is unconstitutional, that the statute is constitutional as applied under any set of facts.
Well, wait a minute. If instead of coming to the nuisance, you operate in a different direction, wouldn't be a violation of common law, right? I don't think. So the statute could be applied. You can't, a resident can't buy a property next to one of these AFOs and say, oh, nuisance, because you'd pay a diminished value, you'd pay a diminished price for the property. So surely, in coming to the nuisance situations, the statute's constitutional, right?
I would absolutely agree, Your Honor, and then we wouldn't be dealing with a motion that instead of an answer to the petition, there would have been a motion to dismiss.
And the statute can be constitutionally applied if the use of the property was maybe a manufacturing facility where the odors didn't matter too much. It seems to me the categorical argument doesn't really work because there are concrete situations, coming to the nuisance, manufacturing situations, and non-residential use of neighboring property where the statute would be fully enforceable, no?
Sir, I think that the most important thing is that the statute's constitutionality does not depend on the particular facts of a case. I think that...
Oh, but it does. If it's going to be an oppressive benefit, I'm sorry, as I read Gackey, and I invite everybody to push back, as I read Gackey, it focuses on the notion of oppressive burden on the property, the oppressive burden that arises from a nuisance. If you don't have that oppressive burden, if on the facts you can't show, kind of a substantial invasion of use of enjoyment, how do you prevail under Gackey?
Well, we think that there are some deep concerns that we have about the way that Gackey is applied. We think that, first, sir, to answer your question regarding how do you apply the facts, how can we apply the facts when we don't know if the law is constitutional? I think that that's a primary concern. And I think that the reason that this is such a primary concern is because we don't think that the court needs to revisit Gackey. We think that the legislature needs to revisit the statutory scheme.
The problem I'm having is that one of the elements is a significant impairment to the property's use, which is the oppressive burden.
Correct.
The problem is if the statute is unconstitutional as applied, and this is when I'm having problems with my mind, that means to me there's always a nuisance and the person should never lose. I mean, tell me where my thinking's faulty.
Well, I don't necessarily think that your thinking's faulty, sir. I think that we have a situation where whether or not a statute is constitutional doesn't necessarily predict what the factual outcome is going to be at trial. I think that there's recent precedent from this case, from this court, that talks very clearly about the fact that the merits of a nuisance case are decided at trial. And when we're determining the constitutionality of a law, that comes prior in time to a determination of the facts.
But it seems to me under the Gackey test and what you're alleging here, and I think the defendants are basically saying the same thing, is that you have to have a trial, before you could determine whether or not the three elements are met. And then you could say it's either constitutionally as applied to this person or it's not. And if you lose, it's not unconstitutional, and if you win, it is unconstitutional. And that's the same as winning or losing. That's my problem.
And I agree with you, sir. I think that it is a problem. I think that the body of jurisprudence that's come out of Gackey is very problematic. I think it's caused, inefficiency in our court. It's caused concern among plaintiffs.
Can I ask a question? In the broadest big picture, is it your client's position that you'd really be better off the way things were, 150 years ago when the inalienable rights clause was adopted, and you had no DNR, no setback requirements, no regulations, and all you had was the common law of nuisance?
Well, sir, the question before the court, as I understand it, is not whether the regulatory scheme has an impact on the constitutionality of the law. I don't think that anyone would argue that the face of agriculture today in Iowa is anywhere near what it was 150 years ago. And I think that we do have to evolve to meet those needs.
But doesn't that get to your point that where you're saying this statute doesn't benefit you? Well, doesn't it benefit your clients? There are setback requirements, there are regulatory requirements, the requirements that apply whether or not the facility would be a common law nuisance, right?
I think that, frankly, defendants are mischaracterizing what the benefit needs to be, sir. The benefit needs to be that the barns, that the operation benefits these plaintiffs, these neighbors, not that the statute benefits them.
And I recognize there's some, I'm sorry if I could just follow up. I recognize there's some language in GACI that might support that, but that seems a very strange way to evaluate the constitutionality of the statute, I think following up sort of on what Justice Wiggins is getting at. Normally, legislation is constitutional or unconstitutional based on different tests that we have, such as the rational basis test, which we applied in Jacobsma. And to then say, well, I don't get a benefit from this law, therefore it's unconstitutional as applied to me. I don't get a particular benefit. That's kind of odd. I mean, there's all kinds of laws the legislature passes that I think are oppressive and that don't benefit me. That's not normally the way we apply constitutionality, is it?
I would agree with that, sir. And I think that part of what we need to come back to in looking at GACI and embracing GACI and reapplying it is the fact that it's the immunity. It's the immunity in that particular statute that's in clear and palpable and direct conflict with the Inalienable Rights Clause of Article 1, Section 1 of our Constitution. I thank you.
You may sum up.
Thank you very much, Justices. I have 13 seconds, I believe, left to do that. Just in sum, sir, whether the court finds 65711 unconstitutional on its face or as applied, the grant of nuisance immunity is not severable from the statute as a whole. If the immunity abrogating individual private property rights is found unconstitutional under any analysis, the statute should fail. Thank you very much for your time, Justices.
Mr. Koch, thank you as well. Mr. Lips.
May it please the court, Chief Justice Cady. My name's Tom Lips. I'm here speaking on behalf of the Iowa Association for Justice in their amicus capacity. The mission of IAJ is to support full funding for the courts, an independent judiciary, and the right to civil jury trial. There are three important dates here. The first is 1857, when Iowa adopted its Bill of Rights. The next, 2004, when the GACI case was decided. And now, 2018, we're discussing it again. The Iowa Bill of Rights, although similar to the federal Bill of Rights, is different. Section 1 of the Iowa Bill of Rights grants to all persons the right to protect your property. The framers didn't wait for the legislature to pass a stand your ground law. They enshrined it in our Constitution. We move forward to 2004. The GACIs were long-standing Sioux County farmers whose home and lifestyle were ruined by the stench from a hog confinement constructed across the road by absentee investors. A factual footnote in the GACI case is that Pork Extra, in order to maintain the air quality for its hogs, vented toxic gases out of the confinement building untreated onto the GACI property. Now, 13 years later, 2018, the factual and legal oppression that ruined the GACI's home and lifestyle is basically the same here. Hydrogen sulfide and ammonia emissions are still being vented from the manure pits, and there are no rules regulating the amount of odor or flies that a confinement can blow onto a neighboring homestead.
But there's regulation of setbacks, and I think, correct me if I'm wrong, but in GACI, I think the setback was 1,300 feet, and under the current setback, it's got to be more than 1,300 feet, 1,375, I think. I mean, so there's been some adjustment, given the regulations. Yes?
The length of the ruler has been adjusted, but not the degree of the interference. I agree that there's different setbacks, but the amount of odor and flies that oppress a person's property, there are no rules on that.
I think you're better off without the statute. I think it's an interesting question. That was Justice Mansfield was pursuing that, and I'd like to just roll it your way.
Without 657.11?
Right, right. I mean, I think the position of the other side as well, the legislature considered competing interests. There was rulemaking, and DNR was involved, and experts were involved, and they came up with some practices. So this process ended up with a framework. So it isn't the Wild West of 1857. Instead, we have a structure that provides the following benefit. You at least are guaranteed certain setbacks, and you're guaranteed certain kinds of practices with respect to lagoons and materials and so forth. And it may not be everything you want, but you got some help, and don't you have to accept that?
In response to that, my personal opinion is, I think the setbacks.
Well, how about give me your legal opinion, frankly?
Oh, well, the legal opinion is, I think the common law rights are better than what the DNR provides.
The council, isn't this just democracy at work? Doesn't the legislature have ample authority to modify the common law through statutes? I mean, we see that in the Comparative Fault Act. They rolled back pure comparative fault to modified comparative fault. Don't they have the power to create or modify defenses or rights of action?
They do, but as the Borman case said, nuisance doesn't depend on negligence, and I don't see this all farmers know that if you're spraying herbicide and it drifts off your farm onto a neighbor's property, it doesn't make any difference whether you followed the label on the herbicide or were careful, you're still responsible for it. I think my time's up, so I'll just sum up here. In conclusion, IAJ supports the plaintiffs in this case. We'd ask you to reaffirm the vitality of the holding in Gakey. Thank you.
Mr. Lips, thank you as well. Mr. Roemerman, rebuttal?
Thank you, Your Honor. I'm going to try to be brief here to give my co-counsel a chance. I want to take issue. I don't think this statute creates immunity. I think this statute creates an additional element. It is very similar to the expert requirement in 668.11 for professional negligence cases. So putting aside all these regulations we're talking about, even if my client followed all of the regulations, the plaintiff could still get to court if they showed that my client violated, they won't be able to show this, by the way, but if they were able to show that my client violated generally accepted management practices for their barns. Very, very similar to the professional negligence where you have to find an expert to say that the doctor or accountant or whatever violated generally accepted practices.
Are those management practices, generally accepted management practices, specified in a rule?
No, they are not, Your Honor.
Or what's the source of those?
Well, the source of that would be the same as the source in like a medical malpractice case. You would have to expert to say these are the generally accepted management practices, and this barn is not following them in some way, in some aspect that causes damage to the plaintiffs.
So those would be set by the industry?
Set by the industry in the same sense that medical standards are set by the medical profession, in that you look around, I mean, and this is not a small thing. There's a lot of science that goes into running these barns. There's lots of things. My clients have planted tree buffers. They're using pit additives. All of the So, you know, you can get some, if there's some expert comes in and says, there's a generally accepted practice that makes this better, then you have to follow
But
it.
what you're doing is you are giving immunity for nuisance because nuisance doesn't require negligence. You're saying you have a cause of action if you prove negligence. So there is immunity, as Gacky says, for nuisance.
And I think that's why Gacky essentially talks about it, making a negligent standard. Yes, this statute modifies common law nuisance with regard to this industry. I don't think there's any question that the legislature...
And gives them immunity for it unless you can prove negligence.
I don't want to bandy words. I say it adds an element to the cause of action. Anytime the legislature adds an element to the cause of action, I suppose one could say it's immunity for from those people who cannot prove that element. But I don't want to quibble about that word. People still have a way to go into court if they, even if the barn is past these really far setback distances, if the barn isn't being run right, the legislature made the judgment that the odor is not onerous at these distances if the barn is being run correctly. Now, if the legislature...
And the legislation they pass must pass constitutional muster. Can they do that based upon the free use of land clause?
Yeah, I believe they can, and here's another place where it goes. I have trouble with the plaintiff's argument. We have no problem. We're not here arguing that Division 3 of the Gecky opinion should be overruled. So if the land is burdened, the plaintiffs are paid for the land or paid for the burden on the land. That's Division 3 of Gecky. Now we're into something different from the burden on the land itself. And that's why this is constitutionally different. All they're doing is adjusting your ability to receive a certain aspect of personal injury damage.
Yeah, maybe. Let's just explore that a little bit. And I'm trying to put this in the proper legal framework, but part of the issue here is you have people living in their homes, and they want to use their property the way people use homes.
Yes.
I mean, they want to barbecue, and they want to do ATVs, and they want to hang the wash and the stuff that's ordinarily part of living in rural Iowa. They allege and they claim and they state in affidavits that they can't use their property that way anymore. Now, under Gacky, it seems to me, their ability to show that burden drives the case. And you're suggesting, I think, that no, their ability to show the burden doesn't drive the case. Instead, what drives the case is these kind of generally applicable standards. Do I have it right that far?
And I think you do have it right,
Okay.
but there's a reason for that. And believe me, I'm not casting stones at any particular plaintiff here, but as
sure.
shown by the brief, the courts are being used for political purposes here with mass torts. We have people in this lawsuit that are 5 miles away from the thing. And
If they can't make a claim, if they've made allegations that can't be supported, there's avenues to treat that.
and I know there are, but those avenues come at the end. What the legislature intended to do here, I think, was to establish a bright line to say, okay, let's weed out the chaff here at the outset. Let's weed it out at coming in the courthouse door instead of coming out the courthouse door. And in order to draw that bright line so that this beneficial industry isn't unduly burdened, the legislature had to strike a balance. And the argument here is, first, can they strike that balance? And then, have they struck the balance correctly? And with regard to can they strike the balance, I think this the entire jurisprudence of this court is that that's the legislature's function, to strike that balance. With regard to the second question, have they struck the balance correctly? This court has traditionally been very, very deferential to the legislature, except where there was just no rational basis for the balance that the legislature struck. Now, when they put the setbacks back a third of a mile and imposed all sorts of other, I mean, there's more setbacks if it's an open pit versus a closed one, and there's setbacks for how you construct these barns. We're not going to take the whole regulatory scheme in this argument. But the legislature has made the judgment that if you do all these things, it's not an oppressive burden a third of a mile away, or in my case, 2/3 of a mile away. And what the plaintiffs want to come in and say, no, we think the legislature's wrong. And they can make that argument, but they make it across the street. They don't make it here. That's our position. I'm gonna,
You
I'm
may
way
sum up.
past. I apologize, Your Honor.
Thank you, counsel, and thank you again to all counsel. The case of Honomichi versus Valley View Swine is now then submitted to the court for its decision. Before adjourning court, let me just thank everyone again for taking your time this evening to be with us, and we hope that what you have seen tonight has added to your understanding of our courts and our process of justice that's given to Iowans to resolve their disputes. From here, we'll retire to our conference room and fully discuss the case and reach a resolution which will end up into a written decision that will explain the reasons for that decision. Every Friday we file our decisions, and if you want to follow the case, you can check each Thursday to see the list of decisions that will be filed on Friday, but it probably will take us several months to conclude this case. And we also have a reception planned on the second floor of this building in the Light Court, and it's sponsored by the Polk County Bar Association, and we'll be down to join you at that reception. So with that, I will ask the bailiff to adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.